The Office of the Presidency and the State Attorney are facing off today with former President Jacob Zuma and others. Now, it's important to stress that the applicants in this matter are government departments and not individuals. This is all in a bid to try to recover 28 million rand that was apparently paid for Zuma's legal fees in his personal capacity. The DA is also involved in this case, and it seems this is their attorney currently making representations. Let's listen in.
The State Attorneys Act. But what is important to note that whilst the SEA dealt with those issues on appeal, it didn't change or alter the full court's decision. In fact, it said that the public could rely on the full court's decision, and it stands unchallenged today. Now, on the question of interest, sorry, my Lord, I must just explain how we discovered the shortfall. That's important. And I will give all the credit to my learned junior, who came to see me, and we sat for many days analysing invoices, BAS documents. It was a monumental task for us, not having been involved in either the full court or the SCA proceedings. And I say this because it's deserving. Ms. Jonker, who is here in court today, I called upon her to assist me with finding the appeal record. There were documents all over, and Mr. Ndebele and I struggled for weeks on end to put the papers together. And then when it came to the accounting, we discovered the missing 10 million rand. And it came from obvious gaps in the accounting, which didn't correlate with certain proceedings. So once that was discovered, obviously it took a long time to get those documents, which apparently came from the archives, and that is with the amount of 10,699,426.62 came from. Now, on the question of interest, the notice of motion was issued without a claim for interest. My learned junior and I, in preparing the application, relied heavily on the constitutional imperatives that were at hand. The two courts never expressed any question of interest, and they simply went as far as to say to merely set aside the decisions, the various decisions of 2005, 2007, and if I recall 2018, to set aside those, and then for the State Attorney then to institute action based on Mr. Zuma's undertaking to repay. That would not be doing justice to the case. That is why both courts held that the State Attorney must render an accurate account, together with an order for repayment. And if it wasn't for that rider, the simple task of setting aside three decisions as having been unlawful on the BA's part in terms of PAJA, and on the EFF's part on the principle of legality, was insufficient. So another round before court would have to steps would have to be taken in that regard. So when the fourth respondent's counter application was filed, we considered what they allege to have been an oversight on the part of the applicants. We took steps, when I say we, council, to prepare in terms of Rule 28.1, a notice of amendment to include a prayer for interest. What ensued there was a long debate whether this was a debt in the ordinary case and whether interest should follow. Ultimately, my Lord, I have to tell you that my instructions were not to claim interest because the courts had not expressed themselves specifically in that fashion. And that is why we abandoned the amendment process. However, as officers of the court, and particularly bearing in mind my own position towards the bench, my learned junior and I have had careful regard to what the DA says about interest. We've also carefully studied Section 2 capital A of the Prescribed Rate of Interest Act 55 of 1975. And we have formed a view that it is in the court's discretion, and the facts of this case would, on the basis of a legal point, consider that interest must follow. We do not claim it, but ultimately we will not oppose the DA's claim that interest be paid. And obviously, had we embarked on the amendment process, this would simply have delayed the matter, and we dealt with it in the best way we thought possible. Now, in respect of our application, and if you have regard to what...
These were live visuals we're beaming to you from the High Court in Pretoria, where the Presidency as well as the State Attorney are hoping to recover millions that were apparently spent for Zuma's legal fees in his personal capacity. That was Advocate George Avacomides. I made a mistake. She doesn't represent the DA but the Presidency, and it's just laying the foundation of how we got here.